Greetings everyone. We are back again with another video in continuation with the last, that was for the purpose of giving you the information regarding Delhi Judicial Service examination. And I hope that you all have filled your application form or are in the process of doing it. Kindly do it by the time, because it takes time. 2-3 घंटे लग जाते हैं कभी कभी सब अपलोड करने में. So kindly be mindful of this fact that you have to fill your application form properly, and once you're done with it, that you can now exclusively devote your time for preparation. Otherwise the filling of the application form and all other formalities will keep on lingering in your mind, and that is anyhow a distraction to your preparation. So kindly do it as soon as possible, and do it by 12th of November. This week should be devoted to at least understanding the strategy, and also to be done away with the filling of the application form and sundry things. And after that, you must be all dedicated towards your preparation. Now, there is a disclaimer that I want to share with you, that maybe you are getting some or the other strategy, or maybe some guidance with respect to how to prepare in this particular 1 month. I do not have that particular area for you, because you understand the fact this 1 month is something that no one can ask you to tread in a particular way. It is something that you have to decide for yourself. I cannot tell you that for these 30 days you must act like this. I can only suggest you certain things, that while you are preparing the way you want to prepare, that what all things you must focus while you are going through that particular way. If you're getting my point, I cannot tell you that you kindly do your major acts first and then minor acts first. Maybe you focus upon those 5 acts which are otherwise not as in other states, for example LLP, this limited liability partnership, or Commercial Courts Act. I will not tell you that you do them first or you do them at last. It is upon you. It is totally upon you to decide. So it is for you to understand that where you are lacking. It is for you to understand that in what manner that you want your subjects to be taken care, because this 1 month is something that you have to take care. So no particular strict guidance I can give to you. I can only take you through certain perspectives which you must consider while you are preparing. So if you are doing your major acts first because you want to take care of the maximum number of questions that are asked from them, kindly do it, because you are more relaxed in the beginning. Maybe because you are more relaxed, you will be reading it thoroughly and properly. But if you think that you have already done that and it should be done at last, then you can start preparing with those particular bare acts which you think that are weak. And because that calm and composure, the mental peace that you want in the beginning, if that is helping you to take care of those subjects which are weak, or maybe those subjects which you haven't read before but you want that edge to be taken, then in that case you must devote your time first on those particular subjects. And how much time is to be devoted, it again depends upon you. I cannot say that in 1 week you should revise all these subjects and all those subjects should be taken care in the last 2-3 days. I cannot say that, because everyone has their own pace. Everyone has their own pace, everyone has their own style of reading things, everyone has their own methods by which they actually remember the facts. What depends is that what facts are very, very important for you to remember. What areas are those which you cannot avoid while you are reading those bare acts. So I am not here to tell you that what you should do the next 1 month. If you have to do these acts first or those acts first, I am not into that. I am only telling you whatever manner you have adopted, by whatever means, by whomsoever's guidance. I appreciate that if you will tread a path in this particular 1 month towards 10th of December, because obviously the time is very less, needless to say. But that does not mean that you should not prepare. That does not mean that you should come in panic. That only means that now you must strategize, and strategize according to your own personal assessment. So in the preparation, there is no universal standard at this point, because you cannot follow that. To follow something, you have to train your mind. You have to bring those amendments into your mind. For example, if you have something else in your mind with respect to the preparation, it does not mean that if I'm going to tell you that this is the path that you have to tread, if you will mold your mind, you will waste not less than 2 to 3 days only to mold the mind to do the way I am asking you to do. So that is a big problem that you will face, a challenge. That is something that I don't want to put. So don't expect me, and even don't ask me that, sir, what act should we do first and what act should be taken at the last. I am only at this point of time, because this is a different situation. If you would have got 2 to 3 months to prepare, I would have given you a path, or maybe 2 or 3 paths, where anyone who is finding any path that amuses the person, or the path that they should tread, then in that case you should have taken, because you have time to mold yourself accordingly. Because there is a plinth, there is a platform by which you prepare. Every mind is different, every perception is different. So maybe you are perceiving in a different way, the other person is perceiving in a different way. And if I want you to perceive in a particular way, it takes time for your mind to train. I've already told you. So I'm not here to tell you that what you have to do the next 1 month. I'm only going to give you a support to tell you that what you should do while you are preparing. That means if you have taken CRPC, what all provisions you should not avoid. And apart from that, I'm also going to discuss few questions, not more than 5 to 6 questions, which are conceptual. That means problem based. Problem based here means a paragraph will be there in the question. Now, before you even find it difficult to understand the questions that are given in the DJS paper, which are of a nature in which a whole paragraph is written, and you get confused that now we have to read so much, now we have to find out things, what is written inside the paragraph, how to quickly just go to the point and take out the answer, not getting entangled in the whole analysis that is there in the facts or the scenario being given in the question. The question is giving you a whole lot of facts. That means they are giving you a whole story, and out of the story they are asking you a reasonability, an objective type question. That means only one answer is correct. Here you do not have to describe or explain that why you think so. You just have to mark a question. You just have to mark an answer. The main challenge is that most of the time that you have got to finish the paper, you are devoting in such kind of examination. And I tell you, that is where the analysis come, that how much time you will be devoting in these questions which are conceptual in nature. Conceptual means having a whole paragraph as a question. If you have a whole paragraph as a question, that means you have to read it to understand it, and after understanding, applying your mind, remembering the provisions, and then also not getting yourself into the confusion of the answers given beneath. Marking the correct answer becomes a very big task for you. So how to take care of these type of questions, what you have to do, and how much factual and conceptual area of the question paper will be there, only to extrapolate that and to tell you that what are the provisions that they frequently like, not seldomly, they frequently like in a particular statute. What will happen with this, that from the past few years assessment, at least we are able to know that how many sections are very, very important for us. What is that particular area from which they ask questions frequently? That means maybe they are asking every year, or even if alternate, it is a big task that you must remember that provision. So there are certain favored provision of every state. So I have tried to cull out all those provisions which are repeatedly asked, so that whenever you are reading that particular statute, it does not mean that you have to do only those sections, but those sections cannot be avoided, and those sections have to be crammed It has to be remembered and retrieved again and again. You have to revise them. You cannot leave even a single fact not known from that particular provision. That is the idea that I wanted to share in this video. So I am not, don't expect that I am going to discuss with you that let's do this now. This week we are going to take care of CRPC. It's you to decide. If your CRPC is strong, you don't want it to be to read it right now, kindly devote your time in those subjects which you don't know. So don't get entangled in the unnecessary things. Maybe don't waste your time in going into those areas which you think that right now is not plausible for you. Yes, the things that you don't know, if you have time and if there is the availability of the content, then in that case you must visit that too. If you can take out time for 2 hours and do it, you must do it. But that too only for the next 2 weeks, because after that it's all about that how many facts you know and you remember them. Getting more is not the solution right now. Again, I am asserting this. You will feel this while you will give examination. Getting more is not the solution. If you don't know anything and if you want that I should read it now. For example, if you have not read about arbitration, if you have not read about LLP or POCSO, read it now. Next 2 weeks are there to devote for getting what you don't know. But if you have a good knowledge of every subject, first you must revise them properly. Kindly remember that what you know rather than cribbing about what you don't know. Because if what you know, if you cannot remember that and you have taken more, mind it, whatever you have taken more in this situation right now will never help you, because your mind needs revision, your mind needs training, practice. It requires doing things again and again so that your body is accustomed to remember that. Your body remembers that. Your mind will retrieve the facts only when you can assertively make it retrieve, and that happens only with revision. Revision is the key. Whatever you know, you must trust that information, that whatever it is, it will come from there. It does not mean that if you know less, everything will be asked from that particular portion. It is not that case. Right now, if you have already taken care of the major chunk of your statutes, you must revise that first. Just a suggestion. Depends on you otherwise. Revise that. First of all, revision should be there. And in the next 2 weeks, whatever acts you do not know, you must also do it along. Because you have to devote not less than 14 hours a day. 10 hours is only for the purpose of sleeping, eating, and doing any other daily chores which are important. Other things are not important for you. Your festival is going to be over on 12th. You are free then. So don't worry about the festivities. After 12th, you are free. Even if you are devoting Sunday, you can read for 5 to 6 hours and then you can make merry. And then from Monday onwards, you are free. If you understand this fact. But understand one thing, that the key is revision, and whatever you know must be revised so that at least those facts which you know must not be, it should not be the case that you are in the examination and you cannot retrieve that. Are you there with me? And what I am going to do right now, I am going to only give you those provisions which are otherwise most favored provision of DJS, so that you know that these provisions we cannot absolve from not doing it. You cannot afford to forget them at least, and the rest is what you have to do. Anyhow you have to do, because you will see that I have taken out few questions from the previous year, from 2022 paper, and you will see that they will ask you questions in such a way that they are straightforward, but otherwise it will take time for you to read. And we will see also the fact that they are giving you 15 extra minutes to read the paper, and then you get 2.5 hours. That means 2.5 घंटा आपको around मिल जाता है. You get around a 2.5 hour for the purpose of doing the examination, 200 questions. Clear? So let us see that how we can see certain facts which will help you to prepare. You have to prepare all by yourself. Mind it. Right now, all what you have to do is to sit with your books. Nothing else you can do. And that will be the lifesaver, for at least for this examination. So, if we see the PYQ analysis, first fact that we understand here is, and mind it, these are just extrapolations. I have analyzed the exam and only then I am giving you these facts. It does not mean that this is what will happen. This is not something universal in every year. Year by year, they change their pattern of asking questions. It may fluctuate, but we have seen the tendency, so we understand that maybe we can strategize in this particular area. Because otherwise, where will you prepare? How will you prepare? You cannot just do everything right now in every manner. So you have to confine yourself somewhere, and you have to understand the trifurcation, or you have to understand the segregation of subjects and the nature by which the questions are asked from that particular subject. That is important for us to understand. Clear? So that at least we will orient our minds in such a way that will help us to attend or attempt the examination properly. So you see, the first fact here is total number of questions are 200. This you know. There are 200 questions. If you see the first part, English and general legal knowledge, this particular part is having a range of 20 to 25 questions. But I consider it is never less than 25. In any given case, we have seen from the past few years, 25 is the minimum that they are asking. Sometimes it may fluctuate, 22, 23, but 25 is a very standard mark, a standard number of questions. From these two aspects is 25. That means what is left out of 200 in law perspective is only 175 questions. That means a good deal of questions, 25, it's not less, mind it. It is 1/8 of your entire quantity. बहुत important aspect हो गया ये. Clear this fact. So not less than 1/8. तो आप खुद ही देखिए, you just see one thing, 25 marks is exclusively devoted to these two subjects. And then in law, the rest of the questions are distributed. What are those? 175 questions are distributed in the rest of the subjects that are 12 in number. That we have already understood in the last video. There are 12 laws, out of which there are 4 laws that generally you don't read in every state. For example, those 4 laws are POCSO, LLP, then there is Commercial Courts Act and Arbitration and Conciliation Act. Now these 4 acts, if you minus, then remains only the 8 acts that generally you read for every state. What you read for every state is also taken care very profoundly, very properly, because whenever you take a course, judicial service examination, for the preparation of judicial service examination, whenever you take a course, online, offline, whatever platform, or even if you read by yourself, you focus upon these common acts first. For example, CRPC, CPC, evidence, contract, SRA, limitation, IPC. You will focus upon these particular acts only, and even the courses, they primarily focus upon these particular acts, and they teach you these acts very extensively. For pre, for mains, conceptual clarity, and every dimension that are involved in these acts are discussed with you. That is what the course is comprised of. If you are going to read CRPC tomorrow with me, it means that I am going to take each and every perspective of CRPC so elaborately that you will know each and everything that could be asked or that you should know in that particular provision. I will discuss with you about what is an FIR. It does not mean that I will only tell you what is an FIR in brief. I will discuss with you the aspects of FIR and each and everything involved in it. What do you mean by an FIR? Where it is given in CRPC, how the CRPC deal with this particular provision of FIR, if it is defined or not. Then in FIR, who can record an FIR? What is the value of a cryptic information? Then what is the concept of zero FIR? And after FIR, what happens? And what can you do before FIR? If the record of the FIR is compulsory or not. These are all dimensions that I will discuss with you in the concept of FIR only, dealing with section 154. So 154 is not what it looks. 154 is something that is having a very elaborative story behind. Each and every aspect is important that I discussed with you, because these all things have come up in the courts time and again to let us know that what it means. And all this information is required for you to remember to take care of the pre and mains examination. So I will discuss with you all these things. So wherever you would have taken course, now right now you cannot do that. Right now you cannot take this information, because if you start reading it now, you do not have time. It is the time for revision, not to take new knowledge. Only for the purpose of pre, I will tell you that you can take new knowledge if you have not done these acts properly. So if you talk about the common acts of all the states, courses generally have all the elaboration of those acts. So these 8 acts are what? CPC, CRPC, Indian Evidence Act, IPC, Indian Contract Act, then SRA and limitation. One more should be there. Constitution of India, I forgot. Constitution, ऊपर लिख देते हैं. Constitution of India. So these are the 8 acts that you generally read very properly. Now if you are going to read now conceptually all these acts or the topics of these acts, you know now that you are wasting your time, because they have to be very conceptually read for mains for every state. Now if you talk about these 4 acts, POCSO, LLP, CCA and arbitration and conciliation, they are not asked commonly in every state. It is very particular to this state only, and that too, if you see, only arbitration and conciliation, only commercial court act will be there included in mains. I have already discussed the perspective of what will come in pre, what will come in mains is not in pre, in the previous video of Delhi Judicial Service examination. If you see first of the few videos that we are dealing with in the Drishti Judiciary website, the YouTube channel. Clear this fact. So right now what you should do is that revise these subjects first. These subjects, these 8 subjects must be revised factually and conceptually, because we have seen the tendency that most of the conceptual questions come from these areas. These 8 acts. Most of the conceptual questions come from these 8 acts. What will help you in the preparation of these acts? Your notes. Whatever notes you have prepared. That is why I always emphasize upon preparing notes by your hand properly, because you can't sit to read books. You can't sit to read commentaries. And it is not sure that whatever information you are getting right now with any video whatsoever will be sufficient enough to give you all concepts that are required, because ultimately you cannot make the notes right now. It will be a big task for you. If you can manage, kindly go ahead, but you understand the fact you have only 4 weeks, not even 4 weeks, I have told you, not even 1 month. Clear the point? So kindly revise the notes that you have prepared for the examination. Notes will help you, first of all, to remember each and every concept involved in that particular provision that you are reading, in that particular subject, and all the topics that are important. Then also, because you would have been told that what all sections are not important in mains, maybe not conceptually but factually they are asked in pre, must revise those two. Because there are several aspects in a particular statute where the question for mains are not created, but for pre it becomes very important. For example, I have taken out a question of that effect in to be discussed with you, but it is asked in a conceptual manner. However, it is a very straight and factual question pertaining to CRPC only. There are several areas which are not asked in mains but are important for pre. You must do that also, because this is a preliminary examination. So the task is big. First, you must know all the concepts which otherwise are asked in mains. Why? Because they ask from that area too. And you must also do those areas which are not asked in mains but are very much pertaining to pre. So both the things have to be taken care in this examination. Talking about the concept, it is not a requirement if you prepare for UP and Bihar or even for Jharkhand. But now even they are changing the pattern of taking examination in preliminary. They are increasing the competition by bringing conceptual clarity within. That means they are asking you from the concepts, something that is not written. Now cryptic information being an FIR is not written anywhere in the CRPC. So you are not seeing it factually somewhere, but it is a concept that you must remember. Case laws, they become a concept you must remember because they ask you from that area. If you get the point. So this 175 question is further divided into these two perspectives, because 12 acts, 175 questions. How many pertains to these 4 acts? These 4 acts will have not less than 50 to 60 questions. So if I say out of 175, 50 to 60 questions will come from these 4 acts, doesn't it create a good chunk of the examination? 25 questions goes to English and general knowledge, becomes a very important area. Out of 175, 50 to 60 questions goes to these 4 particular acts, which otherwise are not dealt in such a good detail that it should have. Unless you are preparing very focused for a particular state. For example, you would have been preparing for DJS from the past 1 year and you would have been focusing upon these 4 acts properly in every aspect. Then you are well versed with it. Because they are not commonly asked in every subject, every state. So these 4 acts, if you have any deficiency of reading in these 4 acts, next 2 weeks are there. I am not telling you that you should follow this, but I am only suggesting you that if you have to take some new knowledge, if you have to read something, do it in the next 2 weeks, in the first 15 days. After that, it is only revision, revise, cram, remember, practice. Take the mock test. Practice the questions. Whatever you have to take, whatever you have to do in those areas which you don't know, or maybe you know that if you do it properly right now, you may have an edge. To be in the competition, you must know about these 2. Kindly do it in the next 2 weeks. If you can. Keeping it for the last will never help for anyone. You may choose to pick any subject, that is your take. But if you do not know anything about these 4 subjects, kindly do it in the first 2 weeks, because then you have to revise also. And if you have not done any of these subjects, these conventional subjects, 8, then there is a problem. The problem is that only if that particular subject is left, for example, Indian Contract Act, you don't know anything about it, but you have prepared each and every other thing, or the rest of the subjects are okay, then in that case you can take, but the next 2 weeks are only important for you. To take anything extra, if it is for the first time you are doing, or if it is for the purpose of filling the gap. For example, you have read them before but not so properly. Now is the time to read them first, so that you are not keeping it at the end, and you will have ample confidence to take care of your examination once you are done with all these subjects. So whatever gaps you have, fill it within 2 weeks. Don't keep it for last, because after 15 days, it is only, again I'm repeating, it is only revision, revise whatever you have done till now, revision, practice, revision, practice, revision, practice, nothing else you can do. That is where you will lead towards the journey of DJS for 10th December. So all those who might be focusing only on these 8 subjects, consider these 8 subjects to be only taking care of 100 to 110 marks because 50 to 60 out of 175 are deducted for these 4 subjects only, because they are asking questions from arbitration not less than 15 in number, and from the rest 5 to 8, 5 to 8. So even if you take it simply to put, even if you take an average that they are going to ask 8 from all, but not less than 10, 12 to 15 from the arbitration, then in that case 8 for 36 and 15, again it boils down to 50. 50 is minimum. 50 is minimum that they may ask you from these 4 subjects. So 50 plus 25, if I deduct, so it could be around 125. If maximum you have to see that out of these 8 subjects, how many questions will come? Maximum 125 questions may come from there. 125 questions from these 8 subjects, 50 questions minimum from these 4 subjects, and 25 from these 2 subjects. Now kindly think, analyze, and then decide that where you have to tread and how you have to go. What all things are weak, according to my suggestion, should be taken first. What all you don't know within the first 2 weeks, kindly prepare that and finish it. Because if you are keeping it for the last, it will never happen. It will never come into your mind, because you are more into, you may say that nervousness will come to you, the emotional outbreak that you will have, the problems that you will face while you are towards the examination. Because if tomorrow is the examination, the emotional challenge that you are facing from the past 2-3 days is unprecedented. You cannot equate that with what you are right now. Right now you are relaxed. The notification has come, you are geared up, you are heated, but it does not mean that you are frustrated or you are right now nervous, or your emotional outbreak is of such a kind that you are confused and you're not able to read anything. The only way to put up with your confidence is, whatever you don't know, kindly do it at the first. This is just a suggestion, but a very plausible suggestion. So whatever out of this you don't know, see that how much marks that they carry in the particular examination. So don't consider that these 4 subjects will be of no use if I leave it, because most of the students are leaving this. Many of the students are giving me the messages, sir, can we leave these 4 subjects? Will that suffice? And why I came late with this video is only because I wanted to see that what should be done right now. The feedbacks that I was getting, the questions that I was getting, accordingly I prepared this particular format of the video. I knew that this has to be discussed. All those who know, that is okay. But for those who are right now confused what to do, for them the confusion must be removed, and kindly keep your own pace. And that pace has to be according to your preparation, according to your day, according to your personal aspects. Maybe there are some who can revise properly, so they might require less time. Does not mean that you must stop working after 5 hours. You must strive to do whatever was to be done the next day on that particular day. If you think that you have revised your 2 subjects today, that was 10 hours to be devoted on that. It is your pace. If you did that in 5 hours, the next 5 hours now should not be left blank. It should be now dedicated to the next day's work. And increase your pace. And those who take time must also devote more time, because you both are in competition. The one who has a good pace, the one who has a slow pace, you both are in competition. You have to increase your time. That person has to increase the number of activities that they have planned for a single day. Less food, less sleep. Just a disclaimer. Less food, less sleep will help you out. Less food, very important. Khana kam khao. Be on liquids. Take multivitamins and keep on working. Don't be glutton. Don't eat full meals. Otherwise you will fall asleep or you might feel lethargy. Don't eat full meals. Try it out. Yahi to mental training. This is what is required. That is why it is said that it is a war. In war, you have to consider dire consequences. In war, you have to consider also those compelling circumstances where you do not have the leisure or you do not have that comfort. That is why you are trained for that. And this is the training. This 1 month can change everything. And mind it is not for only this 1 month. DJS is just another examination. Next examination will come. Rajasthan will come very soon. MP will come very soon. UP is going to come maybe again. All these examinations means a lot. And everywhere when the notification comes, this is what you must practice. That you must leave your comfort zone and then strive hard to get into the competition. So it depends upon the pace. Mind it. These 4 subjects cannot be avoided. These 4 subjects, if you haven't read anything about it, kindly focus upon it first, because you can't do it at last. If you have read about it but not so properly, kindly do it first. If you have read about it and also properly, then you revise according to your own schedule. If you are done with it, these 4 subjects, if you have already done it properly, then revise according to your own schedule. But those who have not done it, and any of the acts here, these 8 acts, kindly do it in the first 2 weeks. If you understand my point. Because the bifurcation of marks is there before you. And you can't also leave English and general knowledge because 25 marks are directly dedicated to it. Any edge that you can have in this particular examination is from these 4 subjects and general English and legal knowledge. Do you have time to leave them? And do you have even guts to leave them? 50 plus 25, 75 marks. If your 75 marks are in trouble, then tell me, out of 125, how much marks can you score? How many questions will you attempt? How many questions out of 125 will you attempt? 120 is the minimum score for unreserved. 110 is the minimum score for reserved. If you are going to only do these 8 subjects and not going to focus upon these 2 aspects, you are anyhow out of the competition. So you cannot leave it. Because after even you do these 8 acts very properly, there will be an area where you may do silly mistakes. There will be some questions where you may get into confusion. There will be some questions where you might not know the correct answer and you leave that. Maybe there comes an unread particular provision that you have not read before. Surprises may always come to you. So even out of this 125, there might be a tendency that you do not know anything about 10 questions, or you mark them negative, or you are confused about them. What will you do then? 125 minus 10, 115, you are out of competition. Negative marking, you are anyhow out of everything. So can you leave these 4 subjects? Not at all. And how to take care of these 4 subjects? Do it factually. See the previous year questions. Arbitration and conciliation, you will have ample of questions, MCQs in PYQ, because it was added long time back. But if you talk about LLP and POCSO, it was added only in the last year. So see, in the last year, they have only asked you some factual questions. So do factually, because they are not asking you this in mains. So conceptual clarity would not be a requirement. But because they are asking you about Arbitration and Conciliation Act since long, that is why now they have started asking conceptual questions from you. But if you will see the number of conceptual questions are still less than the factual. So at least if nothing, you know that in Arbitration and Conciliation Act, if you are reading the index properly and the ingredients of the sections properly and taking the factual information, you can take care of out of 15 not less than 10 questions. 5 questions you can leave if you do not have time to read them. Mind it. It is only to take care of the things. But you cannot avoid these subjects. 50 question means a lot. A good chunk is there. And people who will prepare these 4 subjects very properly will score not less than 45 out of 50. Even if I consider that 5 questions are those in which you might not know anything, you are confused, you are leaving because of that confusion, or you might commit a silly mistake, so that is why you are leaving that particular question. So 5 questions maybe you can leave. You do not have to score 200 out of 200. Even if you are leaving out of these 50 questions, 5 questions, 45 questions will mean a lot to give you an edge. Even out of these 25 questions, you are leaving 5 questions, 45 from here, 20 here, 65 questions are correct from these 2 aspects. Then out of 125, even if you are going to leave 20 questions, 110 will be there. 65 plus 110 or 100 marks if you are going to score out of this 125. So you now calculate 100 plus 45 plus 20. So 100 plus 65, 165 you are scoring. And if you are above 150, you are safe. You can start preparing for mains. There is very less likelihood that it will go above 150. You are totally safe above 150. Even 145 above, you may consider yourself to be safe. But if you are below that, the cutoff may go any particular point, because it is negative marking. 0.25 will matter a lot to set the cutoff. So settlement of cutoff, I cannot say that what will be the cutoff this time. It depends upon the nature of examination, because DGS does not have a repeated pattern or the same kind of examination taking every year. They might change this year. Maybe there will be a situation that they are going to ask you all the factual questions and less of conceptual. It may be a consideration for them, because in the previous years, if you see, there are few examinations that they have conducted which were having not less than 65-70% factual questions. Then what can you do in that? The cutoff will go higher because people would know better. In conceptual, the competition increases. The problem increases. That is why the cutoff goes less. There was one paper, I think if it is in 2016 or 17, there was one examination that was conducted in which the cutoff was 120 only, because that was the minimum qualifying mark. The cutoff was 120. Why? Because whomsoever scored 120, they could not even go beyond 130. It was such a tough examination. The number of seats were less. Examination was very tough. So people were naturally beyond 120. So the cutoff went 120 only. They got the desired number of candidates in above 120. See, it depends upon the nature of the examination. So you cannot put your mind upon this, that what should I should only read factual or I should only read conceptual. You have to do both. But you have to do with a strategy, with some smartness within this time, so that you can take care of this examination, whatever is impending to you. So the cutoff will be seen only after the examination is over. But right now what you have to do is our concern. Right now These 4 acts are very important. Right now, English and general knowledge are very important. General legal knowledge are very important. Right now, to also know that reading conceptually and factually, these 8 questions, 8 bare acts are very important. Wherein doing conceptual questions from IPC are very, very important because they are asking many conceptual questions from IPC. IPC से बड़ा पैराग्राफ बना के देते हैं. तो आपको यही तो बस देखना है कि किसको किस तरीके से पढ़ा जाए. You see that seeing from the past few years, the conceptual part of the question paper is around 75 marks and factual questions from the paper are 100 marks. We are leaving English and general legal knowledge aside. Out of 175, the factual questions that they are asking are nearly 100 questions. And the conceptual way of asking question is nearly 75 questions. That means that it is not even 50-50. Conceptual questions are asked less. That means you can mainly focus upon factual aspects of the question paper. And that is why I am saying that even if you are not so well prepared in concepts, still you must strive to read the ingredients properly. If you do not have notes, if you don't have anything prepared conceptually with you right now to revise, then in that case you cannot take new knowledge. You cannot start reading CRPC now. CRPC will take another 3 months for you to read conceptually. How can you do it in 1 month? And that too only one subject is there. There are 12 subjects. So what will you do right now? To be in the competition, because I know that a major chunk of the questions are factual. And I will tell you that even in conceptual questions, how you can deal factually. It is a straightforward question, but is asked in a way that you will get confused. And there should be no confusion because you just have to see that whatever factual knowledge you have, you can use that to even answer those conceptual areas. So don't get hassled. Don't come into panic. Only seeing that DJs bada hard hai. The only thing I listen from everyone is DJs bada hard hai. Sitting judges are telling me that. जो जज बन चुके हैं वो बोलते हैं डीजेस बड़ा टफ एग्जामिनेशन है. इट इज द इजीएस्ट एवर आई हैव सीन. एंड इफ यू अंडरस्टैंड दिस द nature of the examination, mind it, it could be the easiest ever. If you see the mains examination, this is the easiest way of answering question. It is all about telling the concept and giving the analysis. It has nothing to do with cramming each and every point and then writing everything. It's a 3-page long question and the answer can be given in 1 page. What else do you require? It's a 60 marker and you will get 60 marks even if you're writing 2 pages. Why? Because what is required is different from what is required in other states. DJS is very simple, very easy. You just have right now you just have to focus upon few things. Now whatever suggestions I am giving is for those who have not done it, who are already prepared, who were focused for DJS. They knew that the examination may come at any point of time and we have to be prepared. If you have already prepared, you have done all these subjects, you are good with your content, you are good with your knowledge. The only thing that you have to do right now is to not get into any particular subject in focus. You just have to revise and give mock. Revise and attempt questions. Revise, do PYQs. That's it. The whole month should be devoted to this. Then you stand a chance to write mains perfectly. This video is for those who are thinking of leaving subjects, who are confused what to do because they're not well prepared. They have not done anything exhaustively till now before the notification came. जिनके ज्ञान चक्षु notification के बाद खुलते हैं. But they stand a chance to be in the competition. How? Because they are not totally blank. They know things. The only thing is that they have to now orient things. उनको अब चीजें situation में लानी है कि कि जे 1 महीने में क्या करना है. हाउ कैन वी हैंडल. कुछ लोग बड़े प्रिपेयर्ड होते हैं और कुछ लोग सिचुएशन हैंडल करने के लिए प्रिपरेशन करते हैं. सिचुएशन हैंडल कर लीजिए. And don't think that he has done everything or this person does not do anything. Don't think about them. Be purely selfish. Think about yourself, where you are standing and how can you be in the competition. For that, I am trying to give you a scenario. So where you are weak, what you cannot avoid. You cannot avoid anything, but particularly you cannot avoid these 4 subjects. It means a lot. Otherwise, you are out of competition. 50 questions if you cannot attempt. See where will you be? Out of 150, how much you can score? And even if you are doing 2 subjects only, for example, if you are doing arbitration, 15 marks only you are adding. You have to these all 4. So to be in the competition, you have to focus upon general legal knowledge and English also. Because I give you this situation that in general legal knowledge, you might first of all get entangled in the correct content and then anything that they can ask. They are fluctuating between static and current affairs. Certain things that are not in current legal knowledge, but they will ask you. They can ask you about award. It is not a legal knowledge to ask you about awards. Who got this award? It is current affairs only. And sometimes they are asking only 3 current affair questions and 7 static general legal knowledge questions. Although they are not going to history and geography, not that static general knowledge, they are confining themselves to general legal knowledge, but they in current affairs they are asking you anything. So there is a possibility that the content will be vast, number of questions is less, 10, and you might not know about that particular fact. So there is a possibility that you would have to leave certain question in general legal knowledge. I am talking very practically. Don't take it to be something कि अरे सर आपने छोड़ने के लिए बोल दिया. अरे छोड़ने के लिए बोला नहीं है, छोड़ना पड़ जाता है. There is a possibility that you have to leave questions. You cannot think of each and everything that might come in the question will come in the question, a question paper. You may have to leave it because I've seen those question papers. I've seen people attempting those question papers. And I've seen them, even those who are leaving, even if you have to leave 20 questions out of 200, 180 you must know. Even if you have to leave 30 questions, 170 you must know. Even you know 170 and you are marking them correctly, you are way above than the cutoff. I'm telling you 150 above, you are safe. Totally safe. So don't get hassled into impracticalities. So people are getting they are getting into problem by not getting the correct content of general legal knowledge. You do not have that. You can only read from the past 6 months whatever current affairs you have and whatever current general legal knowledge you have. I will tell you the correct source also. In Drishti Judiciary website you can go. I will give you that source from which you can take the information. In Drishti Judiciary website, we have from the past 3 years, from the past 3 months, we have provided with the consolidated content regarding current affairs related to legal awareness. So whatever current affairs are there attached to the legal awareness or general legal knowledge, in short, you may say, as far as current affairs are concerned, current general legal knowledge is concerned, that is for the past 3 months you have them in Drishti Judiciary website. You can access it. I will tell you where you have to go, where you will find that, so that you're not just going and wasting your time and finding out. At last of the video, I will tell you where you can access those 3 months at least for those 3 months current affairs related to general legal knowledge. But it is not sure that they will ask you from there. We can only think of. But it does not mean that you will not prepare only. You have to prepare. At least that you have with you must be learned. Whatever is there with you, you must do that. You must go with that fact, with that positivity that if it comes, I will not mark incorrectly. I will mark it correctly. Only when you know that you can mark it correctly. You cannot altogether say that we are not then doing general legal knowledge. You can't say that. General legal knowledge has to be done. But you do whatever you have before you. You do accordingly. And if in case they are asking you something that you don't know, then you can have that there, you can have the audacity to leave those 2-3 questions. It does not will be a problem with you. But it does not mean that you will not prepare, mind it. Because I've asked you that you can leave. I have not, you can leave the question. I am not asking you to leave the question. I am saying that you prepare first, prepare very positively. Whatever content you have, kindly do it. Kindly try to remember it. If it comes from there, it is your luck. If it is not coming from there, then you have the tendency to leave those 2-3 questions. It will not make a difference. Because you have that buffer. You can manage. English is very easy. You can take care of English, antonyms, synonyms. And the other aspect, you can take care of it very easily. What they are asking you, spelling mistakes should be corrected. Then there are certain fill in the blanks in which you have to just write that what will come here, predecessor, becomes. It's very easy. If you are well versed in English language, you have communicative fluency and you have been through the books since childhood, you know that you can take care of it. All those who does not belong to English medium, if you belong to Hindi medium, still you can take care of it because your grammar is very strong. Still you can do it. So don't think that people, because they are asking me, we are from Hindi medium, can we give examination? Yes, you can give examination, but English is the only medium of writing paper. English is one of the criteria. Even if tomorrow you're going to attempt mains, if you clear pre, English is going to be very, very important aspect of evaluating the question paper, the answer sheets. English, because they want it to be in English language. Hindi medium is not required to write the examination. So you cannot write mains examination if you want to write it in Hindi. Even if you are from Hindi medium, it does not matter. You just have to clear the examination. They are not asking you to clear your 10th in English or 12th in English. They are saying that the medium of English of giving this examination will be, the medium of language of giving this examination should be English. You cannot write it in Hindi. If you understand this, I think most of the problems are getting solved. The confusions must be kept aside. And more you must focus upon preparing the examination. Less on getting into the confusions. You got the point? So kindly focus upon all these areas. That is why I gave this particular analysis in the first page. I wanted to discuss it with you. Although it does not make sense for many. But I know that if you have this particular idea that from where, how many questions will come and how you have to prepare, then you are well equipped enough to go in a particular area properly. अब आप जब भी ये 4 एक्ट्स उठाएंगे, आपको पता है 50 क्वेश्चन से नीचे नहीं आ रहे, तो इनको जरा तरीके से कर लिया जाए. This POCSO, LLP, CCA and arbitration are not less important than the others. And then you also know, I have told you already that CPC, CRPC, they will fetch around 30 questions. IPC, Indian Evidence Act, not less than 25 to 30 questions. That means a good chunk of 30 and you may say 100 questions will come from these 4 subjects only. CPC, CRPC, Evidence, IPC. Not less than 80 questions, if I say so. Even if I say that they might fluctuate the number of questions, not less than 80 questions. Even if you take it less, not less than 60 questions. Even if you say that they are asking from the other subjects, are so many questions have been asked from ICA. How many questions can they ask from ICA? Maximum how many? 10, 15? Not more than that. SRA limitation. If they start asking many questions from these, then the role of CRPC and CPC will diminish, which we haven't seen from the past few years. We haven't seen that. That is why we have culminated this particular situation or this particular idea that these 4 subjects become very important. This anyhow is giving you the sequence and the focus point of the examination. Even if you have to choose any particular subject, this is how you have to do it. Few people will guide you that major and minor subjects should be taken along. Few will tell you that first you do the local or the non-conventional subjects, first you do that. I am telling you that you do whatever. Do whatever. All are correct. No one is wrong in this particular aspect. You may do whatever you want, but you cannot leave anything, first of all. Second, whatever you don't know or the subjects on which you do not have confidence, do it first. Because at the last you cannot take it. That is impossible for you to read at last. That let me just have confidence on all what I know, then I will see if I have time, I will do that. Don't get into this don't commit this mistake. Don't get into this situation. You will never be able to touch that again. Kindly focus upon that you don't know. If you don't know SRA limitation, do it first. If you know these four, you are good to go. Then you do whatever you don't know. So whatever new knowledge you are taking, do it in the first 2 weeks, because after that it is just revision, practice. You have to get into the idea of doing all 200 questions in 2.5 hours. ये आपको practice होनी चाहिए. Clear so far? And then you can choose that how you have to tread. I've told you already that what all subjects are very, very important for you to focus upon. Then now I want to give you the provisions that you cannot leave at any case. If you are attempting to revise Indian Penal Code, these are most favored sections. Repeatedly asked. That is why I have asked them to give me this information about repeated provisions. This we have taken out from the analysis of the previous year questions, that how many sections are there, or in case not how many, then what all provisions are there where we should focus very profoundly. It does not mean that it is the only area where you have to focus. It is not the only area. You have to read the entire IPC properly. The way you are going to read them, you have to read every other section, because they may ask from anywhere. But there is a tendency that they are asking from these repeatedly. And because they are asking from these repeatedly, when it comes to revision, sometimes when at last you have to revise certain things, first of all, it must go into your mind that once you have revised, or you have revised again, then the facts must keep on revolving inside your mind like it is your life. It is not something which belongs to a particular point that I have read it now and I remember it now, but tomorrow it will go out of my mind. It should keep on going on in revision in your mind. It should be read in loop in your mind. And if you could not remember one particular aspect of it, then you must go back again to the Bare Act and revise it again. This is how you can remember it throughout. This is how you will train your mind to remember the facts throughout, which is the need of the hour. So at last, when you have to, first of all, whenever you are in the first event attempting to revise IPC, revise it in one go properly, every ingredient, every provision that is there in pre. It is important for preliminary. Revise it in one go. Then when you start revising the next time, see that if you remember each and everything or not. If you are thinking that there are certain provisions which you are not able to remember properly and it falls under this particular aspect, that means if it falls under any of these provisions, it has to be revised properly. I repeat again, whenever you are taking IPC, for example, I have IPC in my hand. So if I take IPC and I start revising, I start doing the index, I start cramming the chapters, that which chapter contain what title, then I've started cramming the provisions in general exceptions, general explanations, and each and every ingredient inside it. I'm doing everything properly. Right now, I am not focused on these provisions. I am doing, first of all, everything that is required for preliminary very properly in IPC. When I'm done with it for the first time, when I'm done with it, every provision, every ingredient properly, when I'm done with it, I have to revise the second time. I will start revising again, each and everything. Then I will see that what all provisions are there which I am not recalling properly. Mark these provisions in your IPC Bare Act. Because if once you have revised and if you are revising again, there are certain provisions that you are not able to recall properly. There are certain ingredients that you are not able to recall properly, and it falls in any of these provisions, then you cannot leave it like that, because these are very, very important, because they are asking it from these provisions again and again. So you cannot leave it like that okay, doesn't matter if I am not able to remember this provision or the ingredients of this provision, because I remember the rest. If that provision falls into any of these, that means they are repeatedly asking it. You cannot leave it. You cannot leave anything, but you cannot afford to leave this if you think that I am not able to recall the things out of these provisions. You have to do it then 5 times, 6 times, 10 times, whatsoever it takes to remember that particular provision properly. You must do it with every provision, not less to say, but this cannot be avoided at all. That is the idea behind me giving you these repeated provisions in DJS. And mostly you will find them repeatedly asked in other states too. So if you can mark down these in your Bare Acts, for example, general explanations, section 6 to 52A, all are very important. All provisions, they ask from these. I am not pinpointing on any particular provision. I have asked to, when this slide was being prepared, they were asking me that if there any particular provision should I state, give the entire window so that they cannot leave even a single provision in this particular aspect. General explanation 6 to 52A, all sections are very important. They can ask you from anywhere. तो सेक्शन 6 में क्या है, 7 में क्या है, 8 में क्या है, 9 में क्या है, कहीं से भी पूछ सकते हैं. Where the life is defined, where death is defined, how life is defined, how death is defined, where is special law 41, 42, where is special law defined, local law defined, how it is defined, where public servant is defined, who is not public servant, and mind it, not just this. Remember always one thing, in any statute that you are going to read, illustrations, explanations, and exceptions are very important. I have kept this entire video in English because I don't want you to be understanding everything. I never wanted this video to be in English, and any video pertaining to DJS will not be in English. That means I will not be using Hindi. Even if it requires, then in between maybe I'm doing it, but otherwise for the entire perspective I'm not going to use. For the entire lecture I'm not going to use Hindi, because you are primarily to focus upon this language. So kindly read it in that language. Try to know it in that language. Even all those Hindi medium students who are trying to attempt this particular examination, you must also focus upon listening to the language properly, so that you are there with the examination. This examination does not allow you to write your orders in Hindi. This examination or this service does not allow you to do anything in Hindi. It is English, the official language. So you must start behaving, and you must start being in such arena. That means you must be there with the examination. You must acclimatize with the examination, if you're getting the point. Because many of you have written that, sir please English में भी बता दीजिए, हिंदी में भी बता दीजिए, जो पिछला DJS का वीडियो था. So the thing is that I am doing it particularly for the Delhi Judicial Service examination, and English is the language, so I am using that language only, purposefully. Although my DJS notification video is in both the language, English and Hindi both. There is one exclusive DJS, one exclusive video on in English language that will be not right now important, but it will be released soon. So illustrations, explanations and exceptions, you cannot leave these three aspects while you are reading Bare Act. The questions will be directly asked from these situations. Explanation in any particular provision and exception in any particular provision are asked discretely, differently, exclusively, particularly. Illustrations asked in the same manner. You cannot leave them while you are reading any particular provision. So this chapter becomes important, general explanation. Chapter 2 of IPC. You must also remember the chapter names and titles of IPC. General exceptions, chapter 4, section 76 to 106, they ask several questions from them. This area is very, very important. You cannot leave that, and ultimately you will see that everything I have is covered. It is what is being frequently asked. Punishments, section 53 to 75, chapter 3. Chapter 2, 3, 4, that means are very, very important. Chapter 2, 3 and 4. So while you are reading IPC, chapter 2, 3, 4 have to be focused again and again and again, have to be revised again and again. Why? Because not even a single provision can be left not done. Then focus upon section 299, 300, 301, 307 and 320. They are asking from these aspects again and again. Transfer of malice, definition of murder, definition of culpable homicide, attempt to murder. And 320 I think would be the definition of grievous hurt. And along with 320 I also ask you to read 319, then 323 and 325. 320 the definition of grievous hurt, 319 definition of hurt, then punishment of voluntary causing hurt and voluntary causing grievous hurt. Both you have to do. I'm telling you, first when you will read the Bare Act, everything is to be read properly. Every aspect of preliminary is to be read properly. And then you also have to read conceptually, because I've also told you one thing, that from IPC conceptual questions are maximum. They will ask you conceptual questions. That means they will give you a situation and they will try to find out the answer. And that will belong to this particular statute, IPC. Very important. Then 317 and 361, you just mark them down. Then 304B and 498A, dowry, death and cruelty. 304B and 498A, 378, 382, 405, 410, 425, it's all about mischief and related topics. आप इसी में ऐड कर लीजिए 375 and 376. 375 and 376 should also be added. 375, 376, rape and its punishment and its variations. 375, 376 and its variations. 376 have several things into it. Mark them down. So you cannot avoid to not know anything in these sections, factually, conceptually, both. The questions are mainly asked from, even if it is conceptual, it will ask from, because they are the aspects of mains. Mains में यहीं से questions आते हैं भर भर के. They ask questions from in mains from these sections only, and that is why they become very important for pre also, because conceptual or factual, they will ask questions from these aspects. You got the point so far? 378, 382, 405, 410, 425, then 354C and 354D. Now if they're asking question from C and D, but you also do A and B properly, and you must know the title in sequence and the ingredients properly. C is voyeurism, D is stalking in sexual assault, A is sexual harassment, and B is disrobing. So see that you have to read everything, but they are focusing again and again on certain aspects. Then section 511, attempt. The theories of attempt, conceptually also, the theories of attempt, the concept of attempt, and then what is written there. क्या लिखा हुआ है, it is very important to remember. So if you mark this, I've told you that this is not the only provisions you have to read. This is the provision that you cannot avoid to lose even a single fact. This is to be read again and again so that you do not forget anything written in these provisions at least. Then comes CRPC. Again, the same aspect. I have given a window. Section 41 to 60A, provisions of arrest of a person. 41 to 60A, the most favored chapter in CRPC is this. Every state likes to ask question from this area. 41 to 60A. And not just this, also the cases involved in the provisions in this particular chapter. केसेस भी हैं कुछ, जैसे अभी सत्येंद्र कुमार अंतिल का आया, अरेस्ट प्रोविजन पे DK बासु है, जोगिंदर्स केस है, अर्नेश कुमार की जजमेंट है. ये सारी जजमेंट्स भी बड़ी इंपॉर्टेंट हो जाती हैं. All the judgments pertaining to the provision of arrest also becomes important. Also the amendments that are there in this particular window or this particular phase is also very important. Apart from the cases, the amendments. Focus on these because they will ask question from these. You can, because what happens now, once you are reading the sections, maybe you remember that okay, in 41 this is written, in 42 this is written, in 41A the notice, 41B is this, okay, theek hai, control room, okay, 41C, everything you will remember. But maybe you might lose a particular term written inside. For example, the headquarters must be made, headquarters, police control room should be there. So 41C talks about police control room. It comes from where? Where it has been asked to establish control rooms? In district or in state? You might lose that particular fact. So if you know that you have to focus upon these provisions and they ask from these, you will not avoid that fact that it is both in district and also in state. What is the purpose of that police control room? And after which judgment that it came? When you will take care of each and every fact, what else is remaining for you to mark the correct answer? What else is remaining for them to ask you? पूछ तो लिया, और क्या पूछें आपसे अब वो. अगर आपको इतना ही पता चल गया that if you know that DK Basu is the case, 41C is the provision, talks about police control room, C से control room, याद रख लीजिए. And a police control room must contain the what is the purpose? The purpose is to contain the information regarding the arrests so far made, so that anyone would like to know the information about the missing of a person will first go to the control room and see that if this person is in the apprehension of police or not, in detention of police or not. And this should be made in district and state headquarters, both. As simple as that. All the facts are now known. And this is what you have to do. And these are the provisions that you cannot avoid from not remembering anything. You have to remember each and everything, needless to say. Then again, proclaimed offender, section 82 to 86, one of the most favored sections. There are several things into it, several things. You have several timelines to remember. In this area, you have several timelines to remember. 30 days, 2 years, 1 year, attachment, how much time you get, what can you do. Different things are there inside it. Take out all those points and remember each and everything, because they will ask you questions from this area. Then section 125 to 128 about maintenance. Again, DJS, pre and mains, they will ask you from maintenance. Maintenance is their most favored topic in CRPC. Even in mains, they will ask you from maintenance. And a very good question will be asked conceptually. The 125 to 128, conceptual, factual, both, you have to know about it. Even the cases related to it. Needless to say, cases and amendments whatsoever. Amendments here means that you have to remember the year also. When this amendment came, by what amendment this particular provision came. Then comes anticipatory bail. It's not just anticipatory bail, read the entire aspect of bail properly. 436 to 438, 439, read properly. 436 to 439. Consider it to be 439, but 438 they ask repeatedly. It does not mean that they are not asking from the other sections. They are asking repeatedly from 438. The importance of the section comes here. Compounding of offense, 320. When can the compounding happen with the permission of the court and when without the permission of the court? Very briefly, you have to also remember the sections given therein. Which sections are there where without the court and with the permission of the, without the permission or with the permission of the court, you have to do the sections. 320 becomes important. Limitation of cognizance of offense, 468 and 469. Although this whole chapter is important, but they ask repeatedly from 468 and 469. About limitation, that what is the limitation? There is a table that you have to remember, that if any offense is punishable with 3 years or more, no limitation. If less than 3, then 3 years, less than 1 year. This is what the table that you have to create. Then they will ask from plea bargaining. The whole chapter is important. In this chapter, you have to remember mutual satisfactory disposition 265C is very important. Then they will also ask you that how many sections are there. There are 12 sections into this chapter. 21A was inserted after Malimath Committee 2006. Everything you have to remember about plea bargaining. Where is the concept of mutual satisfactory disposition? 265C. Everything you must know about plea bargaining. Summons trial, then again they will ask you several questions from summons trial and also summary trial. Summary trial भी इसमें आपको बहुत important है. Important तो सारा ही है. Everything is important, but they are repeatedly asking from this. That is why I am telling you that you should not confine yourself to these. You have to read everything, but if while you remember, while you recall, while you are revising, you're not able to recall anything from them, you cannot avoid them. Focus area. Warrant trial 238 to 250. Clear, Ji? Just mark them once so that, again, I have already told you summary trial. It is written here. 260 to 265. Summary trial, very important area. And once you mark these all, you will see that in many states they will ask questions from these sections. Then section 300, 313, 319, very, very important. The examination of the accused, 313. Conceptually, you have to see that. Factually and conceptually both. 300. Factually, you have to remember each and every provision in 300. It is the concept of autre fua convict and autre fua acquit is in section 300. What it means. Then what is all the exceptions given in section 300. Then section 319, adding of an accused at the later stage of trial if there are evidence against him when the accused was not primarily brought into the case. So conceptually with cases and factually both you have to do. Section 161, examination in investigation. 164, confession admissions in investigation by the magistrate. Conceptually and factually both very important. Section 200, 216 and 293. 200 is about complaint proceedings. 216 is about the adding and framing of the charges. 293 I think is with respect to the remembrance of certain provisions which starts from 291. I would suggest you start from 291 to 299 and read them properly. 291 to 299 are very, very important to read, but they are asking repeatedly from 293. And if I'm not wrong, section 293 is reports of certain government scientific experts. So there are a list of scientific institutes, and what report you get from that institute, you have to remember that, because they're asking repeatedly from that particular aspect, that particular section. 293, you cannot avoid to not remember anything here, but 291 to 299 all are important. Anyhow, all are important. Everything in that particular aberrat is important, but these are unavoidable. You cannot absolve to not know anything about them. Then Evidence Act, section 45, everyone knows, expert opinion. 114, again the aspect of may presume, in what aspects you may presume. Section 62, 63, 64, 65, the concept of primary and secondary evidence has to be remembered. Read that conceptually and factually well, because there are several points into it and you must remember all. 57, 32, Diane Declaration, each and every aspect, A, B, C, D, E, everything you have to remember, plus the concept, because they will ask you directly from there. 45, 114, 62, 63, 64, 65, 57, 32. 116, 47 read with 73, section 27, 126. Mark them all. See, I tell you again, the key to preliminary examination is repetition. Repetition plus practice of questions. इसके अलावा कुछ काम नहीं आएगा. Repetition plus practice of questions. Repeat का मतलब है revise again and again and again. जितना रिवाइज करोगे उतना ही प्री अच्छा जाएगा. समझ में आपकी बहुत कुछ आता है, लेकिन माइंड में चीजें रहती नहीं हैं. समझना एक बात है, हो सकता है मेंस में समझ से आप लिख दें, पर अगर आपके माइंड में फैक्ट नहीं है वो पर्टिकुलर जो चाहिए, तो आपके प्री के सारे सवाल गलत होने शुरू हो जाते हैं. समझ से कभी कभी मेंस ठीक हो जाता, लेकिन प्री ठीक नहीं होता. तो प्री में समझ और एग्जैक्ट रिमेम्बरेंस, मेमोरी बहुत बड़ी एस्पेक्ट है. दैट इज व्हाई आई ऑलवेज टेल यू दैट इट इज ऑल अबाउट द अंडरस्टैंडिंग of objective type paper. Objective here means reasonable. Reasonable only have one standard. That means you have to know that perfect answer correctly. If you do not know the fact properly, you will not be able to mark correct answer. तुक्के मत मारना. मैं ब्रीफली आपसे ये भी डिस्कस कर लूंगा कि नेगेटिव मार्किंग के एस्पेक्ट में कैसे क्वेश्चन अटेम्प्ट करते हैं. ठीक है जी. रिपीटिशन एंड प्रैक्टिस, यही की है और कुछ नहीं है आपके पास. प्री के लिए तो यही की है. देन कॉन्स्टिट्यूशन, फंडामेंटल राइट्स, डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी, यूनियन जुडिशरी, द हाई कोर्ट इन द स्टेट्स एंड द रिट्स. दे आर आस्किंग रिपीटेडली फ्रॉम दीज एरियाज. फंडामेंटल राइट्स, द होल चैप्टर 3, पार्ट 3, सॉरी, नॉट चैप्टर 3, पार्ट 3 of the constitution, part 4 of the constitution, and also you read part 4a, Fundamental duties in sequence, A, B, C, D in sequence. Union Judiciary, Supreme Court, 124 to 147, everything you have to remember. And the concepts inside, collegium system, the cases, everything has to be read. High Court in the states, for example, how many types of judges are there, ad hoc, additional, then permanent, and also supervisory power, 226, 227, all these things you have to remember in High Court in the states. Then writs, there are 5 types of writs and the concepts behind the writs. What do these writs do? This is for Constitution of India. CPC. This is a video. See, I may be quick in telling you things, but this is a video. You have all the facility to pause it and then mark. So don't consider that if I am in the next slide, what will you do now? Obviously, you can rewind and see what is there in the page. You can just pause. For example, I just stand here and this is the time you can pause and mark everything written here. You just click to the pause. I'm standing here, seeing you, and you can start marking. So whenever the board is clear, that means I am not coming in between. You can take that particular screen to be a screen of pause and can start marking. Section 9, 10, 11, 13, 14, foreign judgment, about ubi jus ibi remedium, 9, then 10, 11, res judicata, res sub judice, 18, about territorial jurisdiction. This whole chapter is very important. Related to 18 is also 16, 17, 19, 20, very, very important, very important. 42, 96, 42 related to execution, then 96 appeal, 114, the power of review, revision and reference, all are very important, but they are asking repeatedly from these. I've already told you. They are repeating from these sections does not mean that they are only asking these. They are asking from several others and everything, but they are repeatedly asked. Section 55, similarly order 9, order 21, then they have also given you the rules, rule 6, 46, 33, 17, 42. They are asking you from these rules in 21 because 21 is the longest, 106 rules. So they have given you 5 rules from where you have to definitely read. Then order 7, then 39, 39 is temporary injunction, TI, very important area, the whole order is important. 5 summons, then 38, arrest before attachment, 37, summary, 37 is summary suits. Then 14, then you have 18, rule 4 and 3A primarily. 18 is with respect to the trial, the sequence of trial, and D bene essay kahan par hai, or what do you mean by evidence D bene essay, and the demeanor, what all things. But there order, the whole order 18 is very important, but rule 4 and 3A has been asked repeatedly. Then more, section 60, attachment, section 75, supplementary proceedings, section 80, notice to the government, very, very important. Timelines, exceptions, explanation and illustrations are very important. Order 6, then rule 17, 18 and 15A, they ask repeatedly, 8, 10, 12, then 42, 47, that to rule 7, they are asking repeatedly, then 40, rule 3 and 4, then 23. Very, very important. I just be aside and you can pause and mark. Pause here and mark the sections. Then we come, what come next? Limitation Act, section 345, section 6, section 345, 6 and 9, 12, 18, 14, 75, 76. These are the articles from where they are asking that what is the limitation period. Repeatedly, they are asking about the limitation period given in Article 14, 75, 76, 78, 120, 137. Mark them. I think now it makes sense and is easy for you to understand that what is the purpose behind doing this. Indian Contract Act, definition clause, the whole section 2, section 19 and 20, void agreement, section 24 to 30, repeatedly, section 7, acceptance must be absolute, mirror rule of acceptance, section 7, 126, 201, 202. Then what do you mean by the contract uberrima fide? Uberrima fide means utmost good faith, and at utmost good faith it is the contract of insurance is one of the example in the contract uberrima fide. Mark all these, 126, 201, 202 specially. Clear? Then in SRA we have section 6, 12, 14, 21, 39 to 42. Her state mein, every state where you will find these particular subjects, these topics are actually repeatedly asked in every state. It is not only, although we have analyzed it from the previous year question of DJS, but it pertains to every. Then Commercial Courts Act, definition clause, section 21C, section 11, 12, 12A, 15.4 read with order 15A rule 1 CPC. Commercial Courts Act. See what happens, Commercial Court Act has to be read in consonance with CPC, and you will see that whatever provisions you have in CPC and the amendment of Commercial Courts Act has been incorporated there. You have to read them in consonance, because in mains also the question will be asked in some comparison or some interface between the two. So you have to read Commercial Courts Act for mains also, and that too in a perspective that you read it along with CPC, not differently. But here, because it has been added recently, so these are the sections that otherwise we have culled out that you must focus upon, but that does not mean you are only confined to these two. You have to move beyond. LLP section 7, 24, 63, 64, 65 becomes important. Then POCSO section 9, 11, 14, 27, 35. 9, 11, 14, 27, 35. Here, in Arbitration and Conciliation Act, the provisions that are repeatedly asked have not been included in the slide, so I have it differently, otherwise don't worry. So I am writing it here only. Arbitration and Conciliation Act. The provisions which are repeatedly asked are section 7, section 7, 11, 8, 9, then 12, 12, then 34, 36, 37, 36, and 37. Repeatedly asked, but is not confined to this, mind it. In the last year, they have asked from different sections also, very, very different sections, 20, 48, 42, 5, 21. This arbitration is very, very important, because if they are in tendency of asking 10 to 15 questions from arbitration, it's a big deal. It is having no less weightage than Indian Contract Act SRA limitation, because in SRA limitation the number of questions may go less, but in arbitration they are increasing it day by day. I remember in our times we used to give only 3 questions. So at that point of time, if someone was not well versed with the statute, and if they would have left it, it could have helped them, but otherwise not now. So you have to read your Arbitration Act properly, and that too in some way conceptually well. Conceptually भी आपको पढ़ना ही थोड़ा बहुत पड़ेगा, वो थोड़ा बहुत conceptually पढ़ लीजिए, because I don't think arbitration is in mains. So for preliminary, the focus is more on giving the correct answer. So they will be asking you something very straightforward, but a little bit of concept will help you to manage the entire subject properly. So kindly do it very, very properly. Clear so far? Have you marked down all the provisions? Repeatedly asked, but it's not confined to it. I'm saying that again and again. Now let us try to see that how the questions are to be attempted. Very briefly, I'm going to tell you that how the conceptual questions will be attempted, and then I will tell you that in a negative marking examination, how to approach the particular exam. Clear? Let's see. For example, I have a question here. And the question that I have taken out, there are 5 questions, I think. I have taken out the questions from the last year only, 2022 paper, because that is the first paper that you will see. And I have taken out from that examination so that I can discuss with you some fresh questions. So this question pertains to IPC. How do I know? It is not always important that you start reading each and everything inside it. Just try to go to those certain points or certain words that may give you an indication what is happening, because that will help you first of all to understand that which statute it belongs. For example, if you get the first glimpse of this particular question, before even start reading that, what will you do? You will start reading with A and B were married in the year 2013. Married in the year 2013. It may happen that you might think that it could belong to, because you will start applying your mind. It could belong to Hindu law, but Hindu law is not in pre, so where it could, or like, let me read again, let me read ahead. They had one child, okay. After living together for a few years, in January, they decided to separate, okay. No formal proceedings were initiated, but this all is looking like going for Hindu law. Then are they talking about some divorce case, separation, child? Are they talking about some Hindu Marriage Act? So before even you start reading and getting into the confusion, just see that which statute it belongs. So when you see the question, try to take the keyword into it, because you know that what statutes are there in syllabus. They will not ask you anything out of syllabus. You know that pertaining to marriage, what can they ask in the subjects that you have that will relate to marriage? CRPC? Yes, in the aspect of maintenance. Section 125 maintenance may contain a situation where this could be the fact. So section 125 maintenance, just see that if this term maintenance is written anywhere, nowhere, so it does not belong to CRPC. You will have a glimpse of that, and you must, that is why I'm saying key is to revise and practice. Now you will say, sir, how we will do this do this so quickly? This is what the practice is. This is what you will do while you will give mock tests. That is why mocks become important. That is why attempting questions become important. Attempt this question. This is a live question. We have not made this up. It is a 2022 examination question. The result has come this year only, in 2023. It's a 2022 notification. The question belongs to that particular examination. Read it 10 times so that you are accustomed to reading those things that are required. Read it 10 times. You see, maintenance is written nowhere. What is written? Once you are going to have a glimpse of this particular, the whole question, if you get nothing, go to if nothing, go to the answers. The answers will tell you that which statute it belongs. See, B has committed an offense. Offense word, it belongs to IPC. Offense word belongs to CRPC and IPC both. But in CRPC, if you relate this fact of marriage, it can only go to 125 maintenance, or it can go to the cognizance of the offense in complaint proceedings. For example, 198. But it has nothing to do with that. So I know now it is to be associated with IPC, because the word offense here and the whole aspect is going to IPC. Now in IPC, where you will go? In IPC, a marital relationship is, so far you would have read, a marital relationship is confined to few arenas only. Offense against marriage or offense relating to marriage, chapter 2021, 2020A, if I am not wrong. And one aspect of marriage is where you make it an offense in rape. So let us see what it where it situates itself. See now what the facts are. A and B were married in the year 2013. They had one child. This has nothing to do with it. After living together for few years in January 2019, they decided to separate. That means now they are living separately. Move quickly. No formal proceeding were initiated in a court of law. No formal proceeding initiated in the court of law. That means no decree of divorce. No decree of divorce. No decree of judicial separation. No decree of divorce, no decree of judicial separation. No formal proceeding. A and B decided to live apart with mutual consent. In the year 2022, the birthday celebrations of child were taking place, and after the other guest had left and after consuming alcohol, B had sexual intercourse with his wife A. B and A had sexual intercourse. B and A had sexual intercourse. What I am doing, I am marking those areas which are very important for me to decide the answer. What is the first area? No formal proceeding. That means no decree of divorce or judicial separation. ये समझ में आ गया. मेरा दिमाग अभी मुझे बता चुका है कि ये रेप से रिलेटेड होगा. Although you could have you could tell me that सर आप तो पढ़ के आए होंगे obviously, पर जब मैं पहली बार भी पढ़ रहा था तो मुझे मेरे दिमाग में वो सॉर्टिंग हो गई थी, वो फिल्ट्रेशन आ गया था. And that filtration come only due to this exercise. That read and try to attach it somewhere. जब आप पढ़ें तो इसको कहीं रिलेट करने की कोशिश करें. इसको कहानी की तरह नहीं पढ़ना. आंसर निकालना है हमें. कहां किस प्रोविजन पे दिमाग लगाना है उसको रिट्रीव करना जरूरी है. Once you know that this is going towards some rape perspective, so you must find out now, retrieve that which provision is dealt here. किस प्रोविजन की बात करी जा रही है और वो प्रोविजन आपके सामने आ जाना चाहिए. आई बात समझ? So this means that no formal proceeding ये भी हमें समझ में आ गया. नो डिवोर्स और जुडिशियल सेपरेशन डिक्री इज देयर. दैट मीन्स दे आर स्टिल हस्बैंड एंड वाइफ and they are having sexual intercourse. But in what situation they are having sexual intercourse? They are having sexual intercourse. See what it is in after consuming alcohol. B had, matlab husband had sexual intercourse with his wife A without her consent. That's it. This is the third thing. It is, they are writing without her consent. So we do not have to apply our mind that if it is with consent or without consent. Again, they are writing, it is important to remember that both A and B had consumed A and B has consumed alcohol. A और B दोनों ने कंज्यूम करी है अल्कोहल, पर हमें उसमें जाना ही क्यों? क्योंकि पहले ही लिख दिया A विदाउट हर कंसेंट. अगर विदाउट हर कंसेंट नहीं लिखा होता तब भी मेरा आंसर यही रहने वाला था. क्यों, वो भी समझाऊंगा, और अभी क्या होना चाहिए वो भी समझाता हूं. अभी मेरे पास 3 फैक्ट्स आ गए इस पूरे सिचुएशन में. फर्स्ट इज नो फॉर्मल प्रोसीडिंग, कि भाई जुडिशियल सेपरेशन या फिर डिवोर्स का कोई डिक्री नहीं है. इसका मतलब दे आर नॉट डिवोर्स्ड, दे आर स्टिल हस्बैंड एंड वाइफ. सेकेंड, दे आर सेपरेटेड देन विदाउट हर कंसेंट. जब उन्होंने लिख ही दिया क्वेश्चन में, दे हैव रिटन डाउन विदाउट हर कंसेंट, बिकॉज नाउ यू विल बी कंफ्यूज बिटवीन 2 कॉन्सेप्ट्स. द कॉन्सेप्ट इज ऑफ marital rape and the concept given under section 376B. They both will come into conflict with each other. Section 376B and marital rape. अब marital rape जैसी कोई चीज नहीं है because of exception 2 of section 375. A husband can have non-consensual sexual intercourse with his wife. एक तो आपके दिमाग में ये घूमेगा, क्योंकि आपको तो बेस्ट आंसर मार्क करना है. अभी हम आंसर्स देखेंगे तो पता चल जाएगा हमें क्या करना है. पर आप गलत ना कर दें, तो कॉन्सेप्ट आपके दिमाग में सही होना चाहिए. अब ये कॉन्सेप्चुअल क्वेश्चन क्यों है? ये कॉन्सेप्चुअल क्वेश्चन इसलिए है क्योंकि यहां पर दिमाग लगना शुरू हो गया है. वो डायरेक्टली कुछ नहीं पूछ रहे आपसे. If they will be asking about 376B directly, they will be wording the question in a different format altogether. A husband committing non-consensual sexual intercourse with his wife after the decree of judicial separation is, नीचे लिखेंगे rape, not rape, only A, none of the above, it is rape. Where section 376B, वहां तो साफ लिखा है. ये है डायरेक्ट क्वेश्चन. यहां क्या किया? What they have done, they have given you the whole event. आपको स्टोरी सुना दी उन्होंने, और स्टोरी में कुछ फैक्ट्स डाल दिए. उन फैक्ट्स से अब आप कॉन्सेप्ट लगाओ. इसीलिए ये क्वेश्चंस कॉन्सेप्चुअल क्वेश्चंस बन जाते हैं. इनको क्विकली करने का एज सच कोई शॉर्टकट तो नहीं है, मेरी नजर में तो नहीं है, क्योंकि ये आपको बड़े ध्यान से पढ़ने होते हैं. इनको ध्यान से पढ़ने के लिए आपके पास जो टाइम है वो कम है. इसलिए इनको अटेम्प्ट करने का सबसे पहला एडवांटेज या सबसे पहला एवेन्यू ये है that if you want to attempt these kind of questions, the first thing that you must remember is that they will give you 15 minutes extra before examination to read the question paper. If you look at the first page of your question booklet, you will see that they will give you 15 minutes extra to read the question paper. क्वेश्चन पेपर रीड करने का काफी लोग उस 15 मिनट में कुछ नहीं करते. There are many who does not do anything in those 15 minutes. There are many who start reading everything in the question paper. They start reading about the factual questions also. They think that reading question paper means that you start reading the questions from question number 1. Let us start reading questions. No. They are giving you this 15 extra minutes to save your time where the time is consumed. your time is consumed in these kind of questions. You have only 2.30 hours. 2.5 घंटा है सिर्फ, 200 क्वेश्चंस हैं. तो अगर आप एवरेज भी लगाओ तो आपके पास 1.25 मिनट से ऊपर नहीं है, मोटा मोटा 1.25 मिनट. यहां पर ये पढ़ने में ही आपको 2 मिनट लग जाएंगे. इस टाइम को, because you will take 2 minutes or 3 minutes to read this question and then analyze and then interpret, then apply concept and then to mark the answer, you will take not less than 2 to 3 minutes in these type of questions. And they have 40% questions belonging to this category. To compensate the time that you are going to devote in, they have given you 15 extra minutes to read question paper before you begin the examination. You cannot mark the answers in those 15 minutes, but at least you can read the questions so that you can start reading the question and choose from which statute it belongs. That is what I have told you, that once you read the question, see that where it belongs. It belongs to IPC. In IPC, what section? At least try to recall, retrieve, so that you are not wasting time. When you go to this question in the question paper, you will not have to waste time in understanding the whole question again. You have got 15 minutes to do that. Don't just read about any factual question unnecessarily. Don't read about English and general legal knowledge. If you know general legal knowledge, you will mark them correctly in the first go. If you don't know, it does not mean that if you are going to read it first, again by reading you will know everything. So leave them apart. Those questions are not to be read. These 15 minutes are given to you for the purpose of reading conceptual questions. Read them, identify the statute, identify the provision, try to retrieve it and make some concept in your mind. So when you are going to visit this for the marking of the answer, there are many things that will be already sorted in your mind. At least in 15 minutes, if you could read, 15 minutes means even if you are going to devote 2 each, that means you can read 7 questions, if not less. At least 7 questions will be sorted before even you attempt them in the question booklet. 7 questions will be sorted. That 15 minutes, if would have been deducted from 2.30 hours, will take a toll on you. At least that 15 minutes should be utilized properly. So kindly focus upon the requirement, the purpose with which those 15 minutes are given. What generally people do, they start reading everything. Not required. Factual questions are not required to be read. English, general legal knowledge not required to be read. 15 minutes should be used very purposefully to your favor, and that can only be done if you are going to read such kind of questions. Here, now coming back to the question, here what happens, first information I have got is no formal proceeding, that means no decree of divorce or judicial separation. Second, that means they are still husband and wife. The first analysis that I got, the first analogy, they are still husband and wife. Second, they had sexual intercourse, but without the consent of wife. Both are consuming alcohol. Now they are writing, it is important to note that both have consumed alcohol. Doesn't matter. They have written without her consent. And if they have written without her consent, the only thing now it matters is that can husband, without the consent of the wife, commit sexual intercourse? Yes. A husband, if above 18, after independent thought, if the wife is above 18, there's a case now, independent thought versus Union of India. If the husband is committing sexual intercourse with his wife who is above 18 without her consent, is not rape. This is exception number 2, section 375. यहां तो बच्चा है, ऐसा कोई फैक्ट भी नहीं है कि वो माइनर है, मतलब बिलो 18 है, तो मैरिटल रेप तो होता ही नहीं, तो ये तो हो सकता है. But now you go to section 376B. Section 376B says, if I read it for you, very important to read, so that you know that why I have marked a particular statement. 376B says, whoever has sexual intercourse with his own wife who is living separately. Is there a separate living here? Yes, they are living separately. Since 2019 till 2022, 3 years they are living separately. It's a long time. They are living separately. And they are living separately by mutual consent, they have said. That means there is no fault. They are living separately by mutual consent. Who is living separately? Whether under a decree of separation, whether under a decree of separation or otherwise. Whether under a decree of separation. Is there a decree of separation? They are living separately by a decree of separation? No. They are not living separately due to a decree of separation. But then, if there is no decree, will that come under this particular provision? It says decree of separation or otherwise. That means even if they are living separately without any decree, they are living separately by mutual consent, and this fact is established that they are living separately in this question or otherwise. That means no formal proceedings will have no bearing upon the non-applicability of this section. He may be punished for rape. Let's see what otherwise. Whoever has sexual intercourse with his own wife who is living separately, whether under a decree of separation or otherwise, without her consent. ये तो लिखा ही हुआ है without her consent. अब हमें आगे पीछे देखने की जरूरत ही नहीं है, ये तो क्वेश्चन में लिख दिया without her consent. Shall be punished with imprisonment of other description for a term which shall not be less than 2 years but which may extend to 7 years and shall also be liable for fine. That's it. तो इसने तो ऑफेंस कर दिया. कैसे? क्योंकि ये सिर्फ सेपरेटली लिविंग थे. दे आर लिविंग सेपरेटली, हस्बैंड वाइफ, विदाउट हर कंसेंट, और कुछ देखने की जरूरत ही नहीं है. इट इज he has done the offense. Now you look at the options. The first option is B has committed an offense under IPC, which is correct. मतलब बात तो सही है, पर आगे भी देखो ना क्या लिखा है, और क्या पता और कुछ लिखा हो, और इलैबोरेटली कुछ लिखा हो. B has not committed offense, not committed an offense, यहीं काट दो क्योंकि ऑफेंस तो हो गया है. फिर 3 में लिखा है B has not committed offense, यहीं काट दो, आगे पढ़ने की जरूरत ही नहीं है. B has not committed offense, यहीं काट दो. ये तीनों तो ऐसे ही खत्म हो गए. ऑफेंस तो किया है उसने. अगर आपके कॉन्सेप्ट सही है, अगर आपकी एनालिसिस सही है, अगर आपका प्रोविजन रिट्रीव हो गया था, that is why it becomes very important to retrieve correct information and the concept properly. If you would not have read the term otherwise, you would have seen that the decree word is written only. And if you remembered only decree of separation or otherwise is not remembered, then you will mark it incorrectly. फिर आप इन तीनों में से कुछ भी मार्क करेंगे. मेनली आप 2 मार्क करेंगे. क्यों? देखिए, B has not committed an offense. However, the actions of B would be an offense only if A and B were living separately under a decree of separation from a court of law, which is not necessarily required because the term otherwise is also written in the provision, or otherwise, and they are living separately otherwise. Otherwise means by mutual consent or otherwise. Otherwise is otherwise. So decree of separation is not compulsorily required for the applicability of this provision, 376B. So if you remember that provision correctly, you will be confused with no options, and you will mark directly B has committed an offense, which is correct. Answer 1 is your answer. गोला भर दीजिए, बस ऐसा 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 ऐसा, वो गोला भर दीजिए. Simple. First training of mind is to pick which statute and which provision. Second is to retrieve the content. Third is to analyze according to the options given and see what is the correct. Just fill in the circle. Wasn't that easy? Now if I mold this particular paragraph, if I make it more analytical, more conceptual, what I do, I cut this word without her consent. I just cut this word without her consent. Now it is written, In the year 2022, the birthday celebrations of the child were taking place, and after the other guest had left, and after consuming alcohol, B had sexual intercourse with his wife A. That's it. Not written without her consent. It is important to remember that both A and B had consumed alcohol. Both A and B has consumed alcohol. Now this statement becomes important. Once you are not reading without her consent, can you now bring it? Now if the option remains the same, still 1 is the answer, because those 3 options are incorrect. But you tell me that they are writing without her consent. Can this particular fact suffice to prove her consent, that they both have consumed alcohol? B consumed alcohol, that B here, A consumed alcohol means the wife has consumed alcohol. The wife, due to the fact of intoxication, is unable to give consent. Now, if he is having sexual intercourse with the wife, when she is unable to give consent, the definition of 375 falls in section 376B under the term sexual intercourse. How? Just see section 376. This is how conceptually sound you have to be to attempt such kind of questions. Read section 376B first. 376B explanation says, in this section, sexual intercourse shall mean any of the acts mentioned in clause A to D of section 375. That means this sexual intercourse has to be read in consonance with section 375. Once you read section 375, you will see that there is one point. Fifthly, with her consent, when at the time of giving such consent by reason of unsoundness of mind or intoxication or the administration by him personally or through another and stupefying or unwholesome substance, she is unable to understand the nature and consequence of that to which she gives consent. She does not know due to reason of intoxication. Now that has to be seen here, that in this case, because she consumed alcohol does not mean that she might not know that what kind of act they are into. Here they have written without her consent, the matter ends there. But if this was not written, then in that case your analysis would say what? Your analysis would say that because of section 376B explanation and because of 375 definition, fifthly, we could make out the situation because of the dearth of the fact, that means there is no fact in such situation, but we can imagine that if A was intoxicated, wife was intoxicated, she could not have understood the nature of the act and would have given consent. That means it is no consent at all. And if it is without consent, living separately, sexual intercourse, then in that case it's punishable under section 376B. As simple as that. Still the answer is 1. You see, you have to be analytically and conceptually correct to attempt such kind of questions. This question I have included specifically because it looks big, it looks conceptual, but it is very factual, very straightforward. X issues Y a written notice dated 24/10/2015. Written notice, let's see where it belongs. Calling upon Y to concur in the appointment of nominated arbitrator. Once the term arbitrator comes, it belongs to Arbitration and Conciliation Act. You now identify the statute, you just have to identify the provision. Now if you have read the Arbitration and Conciliation Act properly, you would definitely understand which provision it belongs. And to refer their disputes to such person. Y receives the notice on 29/10/2015. Reception of the notice, if you remember section 21, reception of the notice is the date that you must consider. 29 is your date, but declines to comply. The arbitration agreement is silent as to the date of commencement of arbitration proceeding. Directly it is taking you to section 21. Even if you do not remember the section, read the options. Maybe they are indicating something. Option is directly indicating about section 21. When you will go to section 21 of Arbitration Act, you will see there that Arbitration Act section 21 says if there is no date of commencement of arbitration written in the agreement, it should be when the notice was received. So when the notice was received, 29/10/2015. Direct question, direct answer. Arbitration proceeding would be deemed to have been commenced on 29/10/15 according to section 21. This is the answer. आपको दूसरा सेक्शन पढ़ने की जरूरत भी नहीं पड़ेगी, फिर भी पढ़ लीजिए, क्या पता एक बेटर एक्सप्लेनेशन का कोई ऑप्शन हो. Arbitration proceeding will be deemed to have commenced on 29/10/2015 under section 23. 23 में तो लिखा ही नहीं है, 21 में लिखा हुआ है. You must know the section number also. This fact is written under section 21, not 23. Arbitration proceeding would commence only on filing of statement of claim. No, that is not correct. 21 does not say so. Arbitration proceeding would commence only when the arbitrator frames the issues. Not at all. 21 says something. Two ingredients you must remember. Date of receipt of notice. It will be deemed to be commenced. That's it. Section 21. This too is factual question, but it is framed like conceptual. So mind it, there would be certain questions which are very straightforward, but you will get marred into what is written inside. Let me just try to find out what analysis do I have to make. No analysis. Such a simple question. And this is a factual question given the guise of conceptual. ये लंबा लंबा बना के सिर्फ आपको बनाया गया है, इसको conceptual ये है नहीं, ये factual है. तो ऐसे भी बहुत सारे questions मिलेंगे आपको. If you get my point. So that is why you must practice reading the questions so that you can see that in those 15 minutes which section is actually important for me to read. जैसे इससे पहले वाला question, the previous question was important for you to read in those 15 minutes so that you can save your time. That 2.30 hours, you can save time there. This is what you have to practice in the entire 1 month. ये पूरा महीना आपको यही करना है. अगर ये कर पाए तो आप ये पेपर निकाल ले गए, ये मैं आपको बता रहा हूं. इसके अलावा अगर आप अब नॉलेज लेने बैठे हैं तो आप इस पेपर के लिए तो तैयारी नहीं कर पा रहे हैं. ये काम है अब आपका करने का. प्रैक्टिस, रिवीजन, प्रैक्टिस, रिवीजन, प्रैक्टिस, रिवीजन, प्रैक्टिस एवरी डे and devote 12 to 14 hours on that. Similar is the case. This is for proclamation, CRPC, कि आप CRPC में कर सकते कि नहीं. बहुत स्ट्रेट फॉरवर्ड क्वेश्चन है. I just take some other. All right, this question is good. ये क्वेश्चन मैंने डेलिबरेटली उठाया है क्योंकि ये क्वेश्चन इंपॉर्टेंट है, अच्छा है. ये CRPC वाला क्वेश्चन आप आराम से कर लेंगे, इसमें कोई बड़ी चीज़ नहीं है. जैसे मैंने अभी आपको आर्बिट्रेशन का बताया वैसे ही ये क्वेश्चन है. दिस इज़ वेरी गुड क्वेश्चन, दिस क्वेश्चन नंबर 4. आई थिंक आई एम गोइंग टू डू दिस क्वेश्चन एंड देन वी कैन एंड द वीडियो सो दैट मुझे आइडिया देना है, मेरे को ऐसे कोई questions डिस्कस नहीं करने हैं. बट लेट्स सी दैट इफ यू हैव एनी क्वेरी अबाउट एनी पर्टिकुलर PYQ, what I can suggest you is that once you watch this video, if you think that there is a query that you have with respect to any particular question, so give me the year. आप एक काम कर सकते हैं, आप मुझे year of examination and उसका जो question number है, question number and set number, सेट होते हैं ना ABCD, तो सेट नंबर एंड क्वेश्चन नंबर एंड ईयर ऑफ एग्जामिनेशन, कब वो एग्जाम हुआ, वो अगर आप कमेंट में लिख देंगे तो अगर वहां पर सब्सटैंशियली कुछ आते हैं तब एक वीडियो बनाने की हम सोच सकते हैं टू डिस्कस अबाउट दोज क्वेश्चंस, दैट हाउ वी विल अटेम्प्ट दोज क्वेश्चंस. अदरवाइज इट इज नॉट रिक्वायर्ड बिकॉज आपको समझ तो आ ही गया क्या करना है. बैलेट आपके सामने है, कॉन्टेंट आपके सामने है, यू हैव नॉलेज, यू कैन अटेम्प्ट इट, सो नो प्रॉब्लम एट ऑल. See what is happening here. A and 4 of his accomplices who absconded are alleged to have kidnapped G from New Delhi, taking and confining her to several places at Gurgaon. That means they have kidnapped G from New Delhi and taken to Gurgaon. Different places at Gurgaon. अलग अलग जगह ले गए. यहाँ से अभी हमें कुछ ज़्यादा दिख नहीं रहा है कि कहाँ ले जा रहा है ये. In Haryana, from where ransom calls are made and then taken to उत्तर प्रदेश. गुड़ग्राम से उत्तर प्रदेश ले गया, मतलब 3 स्टेट्स में कुछ कार्रवाई हो रही है. न्यू दिल्ली, हरियाणा एंड उत्तर प्रदेश, 3 स्टेट्स. यहां पर ये तो मुझे समझ में आ रहा है कि 3 स्टेट्स को इन्वॉल्व कर दिया इन्होंने, तो कुछ तो इसी के अराउंड होगा. आफ्टर अ वीक her dead body bearing multiple ante-mortem stabs wounds is found at secluded spot in कानपुर. कानपुर में उसकी डेड बॉडी मिली. कानपुर उत्तर प्रदेश में है. अब यहां कहीं नहीं लिखा उत्तर प्रदेश में कानपुर है, ये तो आपको जानना पड़ेगा कि उत्तर गुरुग्राम जो है हरियाणा में बता दिया, और यहां लिखा है where ransom calls are made and then taken to उत्तर प्रदेश. They are not giving you the district. कानपुर is in उत्तर प्रदेश. This general knowledge you must have. Cases are registered by police in New Delhi and Gurugram and Kanpur. Registered नहीं, registered होगा ये, registered. Cases are registered by police in New Delhi, Gurugram and Kanpur. जैसे ही मुझे ये स्टेटमेंट पढ़ने को मिला, cases are registered by New Delhi by police in New Delhi, इसका मतलब FIR तीनों जगह हुई हैं. तो ये कहाँ ले जाएगा आपको? या तो आपको ये ले जाएगा कॉग्निजेंस पे, हु कैन टेक कॉग्निजेंस ऑफ द ऑफेंस, विच कोर्ट, या आपको ये ले जाएगा कि दैट वेयर इट शुड बी ट्रांसफर्ड, कि एक अलग अलग जगह पे रजिस्टर हो गया है केस, एक ही जगह पे ट्रायल होगा, तो या तो ये ट्रांसफर की बात करेगा. ऑब्वियस ही बात है ना, फैक्ट्स पढ़ के मुझे प्रोविजन समझ में आ रहा है कि कहां ले जाना चाह रहा है मुझे. तो ये पढ़ते ही, अब ये क्वेश्चन देखो उन 15 मिनट में पढ़ना कितना इंपॉर्टेंट था. एंड माइंड इट, आप रफ नोट्स भी लिख सकते हैं क्वेश्चन पेपर पे एट द बैक ऑफ द क्वेश्चन पेपर. एट द बैक ऑफ द क्वेश्चन पेपर यू कैन राइट रफ नोट्स. तो अगर कुछ भी ऐसा करना है तो आप अपने क्वेश्चन पेपर के बैक पे लिख सकते हैं, ऐसा अलाउड है. गिव मी अ मोमेंट, आई जस्ट शो यू द क्वेश्चन पेपर. देखिए, ये आपका क्वेश्चन पेपर है, ये 2022 का क्वेश्चन पेपर है मेरे पास. इसमें कुछ मैंने इंपॉर्टेंट पॉइंट्स मार्क कर रखे हैं, और ये आपका लास्ट पेज, द क्वेश्चन एंड्स हियर, द 200th क्वेश्चन इज एंडिंग हियर, एंड दिस इज योर स्पेस फॉर रफ वर्क एट द बैक. यू कैन राइट एनीथिंग अबाउट दिस क्वेश्चन हियर, नोवेयर एल्स, नोवेयर एल्स. ये पूरा ब्लैंक पेज आपको इन्हीं क्वेश्चंस की नोट्स बनाने के लिए काम कर सकता है, क्योंकि कई कबार आपको एनालिसिस करने में प्रॉब्लम होती है. इन माइंड इट बिकम्स डिफिकल्ट टू एनालाइज सिचुएशंस. इन दैट केस इट बिकम्स इंपॉर्टेंट टू यूज दिस रफ वर्क, एंड फॉर एग्जाम्पल यू क्विकली कैन राइट क्विकली द क्वेश्चन number and then the analysis that you have regarding that particular question. Clear? So you can do it here at the back, not in the question paper, but at the back. Don't write anything in the question number. If you are attempting this question, don't write anything here only. Clear? At the back. This is the space that is given to you. And before I proceed, there is a very important point on point number 5 that I told you. Point number 5 of the instructions to candidate, it is written the duration of test is 2 hours 30 minutes. 2.5 घंटे का पेपर है. In addition, you are allowed 15 minutes time before the examination begins. 15 मिनट और मिल रहे हैं एग्जाम शुरू होने से पहले, 10:45 to 11 AM, during which you should read the question paper and if you wish highlight or make notes on the question paper. Now you may ask me that in 15 minutes, if we are going to read such kind of questions, where will I mark the rough notes? Is it allowed to work on the rough space? Yes, they are writing it, during which you can highlight or make notes on question paper. You can use this rough space, you can highlight the questions and can make rough notes. You can talk about this particular thing in your space provided. क्लियर है? मैं नहीं बोल रहा हूं, पॉइंट नंबर 5 बोल रहा है. I will try that if these 18 instructions can be given to you in this video at last by the edit team, it could be done. I will make it this available to you. Then point number 9 is important. Use only blue, black ball point. Only ball point pen. Not gel, not pilot, nothing. only ballpoint pen, either black or blue. No pencils. No pencils. Only pen. That too ballpoint. That too black or blue. No red pen, red ballpoint, no green, nothing. Black and blue. So if you know about these things at that day, you are not confused. अरे क्या ले जाना था? क्योंकि ये तो क्वेश्चन बुकलेट पे इंस्ट्रक्शंस है ना, आपके एडमिट कार्ड पे भी हो सकती हैं, पर उससे पहले आज ही जान जाओ. Point number 13 is very important. Rough work, if any, is to be done on the question booklet only. No separate sheet will be provided used for rough work. जो भी rough work है, जो भी highlighting है, वो question booklet में ही होगी. जो आपको मेनली रफ वर्क करना है स्पेस पे करिए. अगर उसी क्वेश्चन के आसपास इर्द गिर्द कुछ लिखना है तो हाईलाइट कर सकते हैं, थोड़ा बहुत लिख सकते हैं. दैट्स इट. नथिंग एल्स इज अलाउड. क्वेश्चन बुकलेट में ही कर सकते हैं. इज दिस क्लियर? दैट इज व्हाई आई वांटेड टू शो दिस बिकॉज इट पर्टेन्स टू द रफ नोट्स दैट टू बी मेड. अब देखिए, जैसे ही मुझे 3 स्टेट्स दिखे और ये स्टेटमेंट आया, केसेस आर रजिस्टर्ड बाय पुलिस इन न्यू दिल्ली, गुड़गांव एंड कानपुर, I understood one thing, that it will pertain to taking of cognizance by which court. कौन सी कोर्ट कॉग्निजेंस लेगी? सेकेंड पॉइंट डेफिनेटली विल बी रेज्ड, ट्रांसफर करके किसको दिया जाए और ये ट्रांसफर करेगा कौन. अब ये देखते हैं कि इन तीनों में से इस क्वेश्चन में क्या चीज इन्वॉल्व है. what we have to see in this particular question. There are 3 aspects that comes out reading the question till here. You understood this? A is arrested by Kanpur police, an interrogation leading to recovery of weapon. Doesn't matter. The personal articles of G are recovered from the place of confinement in Gurgaon. C, personal articles of G, the kidnapped, is taken in Gurgaon. The weapon is recovered from Kanpur. The evidence is shared by the police in each state with their counterparts in the 2 states. Every state has shared evidence with each other. Every state. Whatever New Delhi found, gave to Gurgaon and Kanpur. Whatever Kanpur found, gave to Gurgaon and New Delhi. Whatever Gurgaon found, gave to Kanpur and New Delhi. Clear? So now, see, state reports of investigation on such basis under section 173 of code are filed by police seeking trial of A on charge of the offence. Now what happened, that they respectively filed the charge sheet in their Ilaka magistrates. Every police station has their Ilaka magistrates. What they did, they filed the reports under section 173 police report to every such. That means the charge sheet has been filed in all the 3 states. There are 3 different states, 3 different districts of kidnapping for ransom and murder in Kanpur, Gurgaon and New Delhi. तीनों districts में, तीनों states में ये मैटर डल गया. चार्जशीट डल गई मतलब कॉग्निजेंस लेंगे उस पे. नाउ द 3 courts, 3 इलाका magistrates will take cognizance on these offenses because reports have been filed before them. The problem will come with the trial, that there cannot be 3 independent trials running because there may be then conflict of judgments. That is why now the question will come to the transfer of case. Now let's see what they are asking. Cognizance of such report having been taken by jurisdictional magistrate summoning A as accused. All the 3 has summoned A to come to their court. Now A is going to be in the jeopardy कि मैं कहां जाऊं भाई, तीनों डिस्ट्रिक्ट बुला रहे हैं एक ही बात के लिए, इसको एक जगह कर दो. अब क्या होगा, either they will ask you that which place should the trial conduct, but CRPC nowhere says that trial can be conducted on one place. As far as jurisdiction is concerned, all 3 have jurisdiction because in part cause of action has happened everywhere. If they have jurisdiction, the cognizance can be taken by all the magistrates and they have taken it. So no flaw. A is now in problem. A is saying that I will go for the same thing everywhere. Now let's see the options, what they want. The High Court of Judicature at Allahabad shall decide as to court at which place will inquire into trial the offence. See, आ गया ना transfer पे. Now they are talking about transfer of cases. And in transfer of cases, they are deciding, when I read the options, they are discussing which court of judicature will decide about where to transfer. If it is Allahabad, because of Kanpur. If it is Punjab and Haryana, because of Gurugram. Or if it is New Delhi, because of New Delhi. The High Court of Delhi कर रहा है. कौन सा स्टेट करेगा? For this, now you must remember that what is the provision regarding transfer of cases, who can transfer. For this, section 186 you must remember. 186 says that in which first in the point of time the cognizance was taken. If I read that for you. Section 186 CRPC says when two or more courts have taken cognizance of same offence, यहाँ पे 3 कोर्ट हैं, and a question arises as to which of them ought to inquire into or try that offence, the question shall be decided if the courts are subordinate to same high court by that high court. Now the courts are not subordinate to same high court. There are 3 states, 3 different high courts. So ये तो point गया. B पे आते हैं 186B. If the courts are not subordinate to the same high court by the high court within the local limits of whose appellate criminal jurisdiction the proceeding were first commenced, उस high court के अंडर जहां पर प्रोसीडिंग पहली बार कमेंस हुई, by the high court within the local limits of whose appellate criminal jurisdiction the proceedings were first commenced, and thereupon all the proceeding in respect of that offence shall be discontinued. तो कौन सा हाई कोर्ट डिसाइड करेगा? जिसके अंडर, जिसकी जुरिस्डिक्शन के अंडर पहली बार कमेंस हुआ, मतलब द प्रोसीडिंग फर्स्ट कमेंस्ड. द प्रोसीडिंग कमेंस्ड वेयर? क्या उसका कोई भी आइडिया है? ये देखिए, ए इज अरेस्टेड बाय कानपुर पुलिस, एन इंटरोगेशन लीडिंग टू रिकवरी ऑफ वेपन, इट स्टार्टेड इन कानपुर. द प्रोसीडिंग, द क्रिमिनल प्रोसीडिंग फर्स्ट स्टार्टेड इन कानपुर. कानपुर इज इन यूपी. यूपी हाई कोर्ट इज हाई कोर्ट ऑफ इलाहाबाद. हाई कोर्ट ऑफ इलाहाबाद योर आंसर. अब section 186 has to be read properly. If you see section 186 falls under jurisdiction of criminal courts in inquiry and trials, chapter 13 becomes important for you to read. High court to decide in case of doubt, district where inquiry or trial shall take place. Which high court? Otherwise you would have gone to a different chapter. I tell you, you would have gone for this particular for this particular section, for this particular question, you would have gone to chapter 31, transfer of criminal cases. But that tells you that general transfer happens what? But this particular point is pertaining to, if you see the options, the pertaining to which high court will transfer. But for that you have to go to section 186. And that is why not leaving anything is not an answer. You have to read each and everything properly, because such kind of questions might also come. That is why I choose these questions. I hope you understand this whole aspect of video, that why I discussed with you several things and these questions, so that you might not deviate yourself into unnecessary task right now. What is required is to understand the pattern of question paper, the manner in which you have to attempt it, and that can only be done when you will quickly revise, finish your revision and start practicing. Then you get into the position of revision, practice, revision, practice, revision, practice in loop, and ultimately you will see on that day it will look like another mock and you will clear the exam. I give you my words. Do this, revision, practice, revision, practice. This should be in loop, and time is ripe. Whatever new you have to read or whatever remaining you have to read, kindly do it within first 2 weeks. Just finish it off, everything, and rely on that whatever you have read. But revision, practice should be your daily routine, and after 2 weeks it should be just the way, revision and practice. If need be, I will come up with some more such kind of things shortly. Let's see. And thank you very much for this particular video. We'll see you again.